getting the legal notices, and this particular topic is regarding to sending of the legal notices. Now, when it comes to sending up of legal notices, what all things which we should keep in mind, what all are the do's and don'ts, how to manage our the entire aspect of sending the legal notice, and all those things we'll discuss some practical aspect to it. Now, just to give you a brief background, what we did. So, LawKNIT Learning is a quarterly session for our clients, and this is basically a training session for the sales, finance, legal, HR team. And the way we try to present it is like not using too much of legal jargon, keeping it more for non-lawyers to understand and effectively manage their day-to-day legal issues in their organization. Now, the roadmap for the today's session is, first and foremost, at what stage we should decide that we need to send a legal notice. Okay, so understanding the stage at which we have arrived, and it is a stage where we should now be sending the legal notice. The second is the modes of sending the legal notice. That how what all are the different modes and what all are the modes which are recognized under law for sending legal notice, and then some immediate, medium, long-term actions with regard to legal notices, avoiding common mistakes. And what will happen if the other side or the other party is not accepting the legal notice, or there is a change in address? They're not at the current address, whatever they mentioned in their agreement. Then how to handle that? And lastly, we'll also deal with when you are entering into an agreement with a foreign company or a foreign resident, and you need to send a legal notice to a foreign party. So does the rules change when we are sending a legal notice to a foreign party? So these are some of the common areas, common aspect which we will be discussing today. Now, coming to the first and foremost, the point that at what stage we will decide that we have to send a legal notice. Generally, this part we discussed last time also, that whenever we come to a stage where now we want to give a final, final communication from our side that this is the finality. After this, we will move ahead with the next course of legal action. Now, when to decide that the finality has come, there can be multiple factors, multiple reasons. Some of the most important and foremost reasons are limitation period. When your cause of action means the reason for which you are going to send the notice is crossing the limitation period, or is there is any requirement under the notice that you need to send a legal notice 30 days and give them a cure period and all those things to rectify the mistake. If that not happen, then only you can go for a filing into a case or a arbitration proceeding. So there can be multiple reasons. You need to understand your reasons, but yeah, there are certain stage where one has to take a decision whether to send the legal notice or drop the matter forever. So Amol, generally when it comes to sending legal notice, from a client perspective, how do you gauge that this is a stage now we should advise our client that you should send a formal legal notice to the other side?
Yeah, thank you, Arnab. So, I mean, if you remember, we discussed last time that there are two or three things that we need to take into consideration when we send a legal notice. First and foremost is obviously, as you mentioned, is the timelines or the statutory or contractual timelines that are specified. So there's a time of limitation act that's there. There are certain specific statutes which provide for certain specific timelines for notices to be sent and timelines to be provided for the other party to respond. Or then there may be certain contractual agreements that you have captured in your commercial contracts as to what kind of a notice has to be served at what stage, to which address, to which noticee, what all should be captured, and what will be the effort from the side of the parties when such a notice is sent, and at the end of it, if it culminates into non-resolution of a dispute, what all parties can do. So these are few of the things that you need to take into consideration so far as the time of limitation or the limitation period for you to send the notice is concerned. The other factor could be uh, that you've reached in your commercial transaction, you've reached a stage where you find no solution to the dispute or breach or problem that has arisen between the parties, and you feel that there's just one last opportunity, as we discussed again in the last presentation also about the reasonable opportunity of being heard to be given to the other party, where you feel that this is my last opportunity that I'm giving to the other party, and post that I'll approach the appropriate court of law or a judicial forum to resolve my dispute. Uh, at that stage, probably you will end up sending the legal notice. Uh, Other than that, this slide also covers certain things which we are anyways going to cover on the uh, other
Essential.
slides as to
Yeah.
what all. Yeah, so in
Yeah.
essentials we'll cover. So I'm not taking uh, those here. But
Yeah.
yeah, essentially it's the timelines, either prescribed in contract or the Limitation Act, or if it is a dispute under certain specific statutes, then the timelines provided under those, or a timeline where you feel that it has been enough of an opportunity given to the other party and now it's time for us to approach the judicial forum. That's the point when you actually end up sending a legal notice to the other party.
So there's one more point which is coming to my mind right now, that suppose there is a cause of action, the other side has breached certain provision of the agreement. Okay. Now the two parties entered into an agreement. One of the party has breached a provision of the agreement. We know that he has breached the provision of the agreement, and we had all the rights under this agreement to send a legal notice to that person. Okay, but we didn't send it for a reason that we kept on thinking, we kept on internally discussing in the organization that what should we do, and the agreement continues forward. The further services were provided and all those things. Now
Yeah,
after some time, suppose 8 months, 6 months, we see that whatever we missed not sending that person that day is causing a problem today also. That's a mistake which we made. Now,
yeah.
after 8 months, while we are continuing with the agreement, if we want to send a legal notice for something which has happened 6 months back or 8 months back,
Hmm.
would that count as a waiver because we continued the services under the agreement, never raised this issue, and after 8 months, so all of a sudden we want to send a legal notice? So will that be a waiver from the other side? Where the other side will say that you have waived it. You can't come back to me after 8 months for this issue.
Yeah. So the answer to this query is not very simple because it will depend from the facts of each and every case as to how they have transpired, as well as the framing of your contractual terms also will define whether that not sending of legal notice for a specified period of time, and then continuing with the services and the contract as usual would amount to waiver of your rights or no. But keeping that factor aside, there is a concept of continuing cause of action under the civil law, where if a cause of action has continued for over a period of time and still continues to cause enough harm or damage or losses to me as a party to the contract, I may still send out a legal notice stating that it is a continuing cause of action, and therefore the notice that is sent today, which is 6 months or 8 months down the line, is also a valid enough notice. Uh, However, we'll still have to see, and it's a subject matter of evidence as to how those losses or damages that are caused for the past period of 6 months uh, can be claimed if I have continued with the contract knowing fully well that there is a breach that is continuing, but that's a different issue. So I can take recourse to that continuing cause of action thing and still send the legal notice. There may be a possibility that the contract very expressly covers that if a party fails to send out a legal notice within a specified time period and then continues by performing its own obligations under the contract in future, it may be deemed to be a waiver. But I've seen cases where, despite having that written clause in the contract, the parties were successful enough to convince the court that it was indeed not a waiver, but either an ignorance or maybe because it was a continuing cause of action, they still stand a chance to send the legal notice. So it will
Got it.
depend on a case to case basis and a fact to fact basis.
Got it. Coming to the next point. Yeah. Now, generally, we keep sending email reminders to the other side. There's something, same issue. If something has happened, we keep sending. Now, whether that email reminders will qualify as a legal notice for us, or a legal notice means a legal notice set on a letterhead signed by a lawyer, sent to them. How does it works?
So this we discussed in last conversation also, right? I mean, there's no specific definition of a term legal notice per se. A notice sent by a lawyer capturing certain things which we again discussed in the last presentation, and making either a demand for money, or asking a party to refrain from doing certain things, or demanding a party to do certain things, is typically treated as a legal notice. Now, sending off routine business reminders, it may not be treated as a legal notice, but if it is a notice sent in-house, capturing all those details which you actually want to capture in a legal notice, and then asking the party that if the demands are not met, or if the compliance is not uh, done within a specified time period, then we'll be forced to take legal recourse. Then it's kind of a uh, it kind of takes color of a legal notice, or at least is a notice which threatens a legal action as the next step, or a judicial, quasi-judicial action as the next step. In that case, it may be treated as legal notices. There are certain organizations which have large in-house legal teams also, and they prefer to send all those notices in-house. Uh, and those are pretty well treated as legal notices. Having said that, there are certain statutes or certain regulations under which you need to capture certain specific things in your notices or demand notices that you send out to the parties. So it's very important that those things are kept in mind. The timelines as prescribed by the statutes are met. Uh, the specific demands that a statute requires it to qualify to be a demand notice under that particular statutes are uh, uh, articulated well in the notice, etc., has to be taken care of, which typically lawyers would know in their normal course, and therefore, if you're not aware of those kind of things, then it's best to go to a lawyer
Yeah.
and get a legal notice drafted.
Yeah. So technically, when someone is sending emails to other side, it can be a normal business email. The distinctive factor is that when you want to send a notice, just mention your agreement and that particular notice clause or a dispute resolution clause which is there, which asks you to send a notice to the other side in case of any dispute. So the moment you say that clause 15 of our agreement itna, which requires me to send you a legal notice or highlight it to you for 30 days for a cure period so that you can cure, otherwise a legal action will be taken. If that much is added to a email body, that intention is very clear that this email is not a general email. It is being sent for a particular purpose, and that purpose is captured under that notice or a dispute resolution clause. So email can be, cannot be, depends on how you write it.
Yeah, correct.
Now, coming to the essentials of notice. Now, why we want to discuss essentials of notice? Not because we want you to, our client to get trained in drafting legal notices for us, but what we wanted to say that these are the essentials. And when, as a lawyer, or when you are discussing with a lawyer, how you should prepare yourself, what set of document or what set of I will say the fact sheet you should be ready with so that your lawyer can effectively and fast efficiently draft the legal notice for you. Okay, because basically as a lawyer or as a third party, I can draft a legal notice on the inputs given by you to me, right? So how to give that input, or what all are the things which a lawyer would look into a matter for drafting a legal notice is covered under this essentials of legal notice. Okay, so from an introduction, grievance, and all those things, the most important part which I always see is first that you should be very clear with your fact sheet, and fact sheet means fact sheet. Whatever you claim and demand is not a fact sheet. Okay, it is something which you want to claim. Fact sheet means the sequence of events, and if you can frame that sequence of event in a chronological order, I think that's half of the work done for lawyer, because then he can relate the document, he can understand that what happened after what, which emails would have been sent after which things. Because what we have seen that a lot of time clients send all the emails to us, all the details to us, and then we will have to figure out into those emails that what has happened actually between these two parties. So, technically, you need to understand that what all fact sheet and what all are the documents or emails, and how to give it to a lawyer and brief it to a lawyer that the notice comes out well and it clearly shows the grievance or the demand you want to ask from the other side. About any specific way as a in-house counsel in your earlier role you used to brief your client or used to maintain the file for something for which a notice has to go?
Yeah. So, one basic rule that one must follow or one must keep in mind is your case or plaint or suit or whatever you may want to call it, or a legal notice, which is a first step towards filing a plaint or suit, is as good as your brief. So, the better the brief that you give to your lawyer, the better your case, and then therefore better your chances are. Uh, with this principle in mind, what you essentially need to do is to capture all the fact, as Arnab said, it's a fact sheet that you need to create. Now that fact sheet captures all the facts. It may not be necessary, or rather, it's in fact necessary for you to keep capture all the facts which are for you and against you. Uh, a chronology of events, preferably a date-wise events, and mentioning of uh, relevant documents which refer to certain events happening on those specific dates makes a hell lot of sense for somebody as a third party, say a advocate who is listening to the entire uh, narration for the first time. It makes life simpler for him to understand the exact issue. Uh, so that's where the briefing or the first capturing of our fact sheet starts with. When it comes to drafting of legal notice, obviously it is a kind of a story narration, right? You start off with introduction of your characters or the parties, addresses, what kind of relationship was there, what sort of agreement the parties were into, and then start narrating the story. Now, those narration of story is from the point of view of dispute, not the day-to-day events that have happened so far in the life cycle of the contract, but relevant to the dispute. After you narrate the story, what has this story led to, which is your grievance. Then, once you narrate the grievance, why you are aggrieved is something that is captured. Then, why what you are saying is right, which is the legal basis of your grievance, or rather making a demand. And then you make a demand as to what do you want the other party to do. So that kind of completes your entire narration. You've told parties their relationship, the contract, relevant clauses, then how the grievance has arisen, what is the legal basis for you to believe that you are right, and then what do you want the other party to do. Once you do that, then comes the time frame as to what and within what time do you want to, because as have been repeatedly saying, this is your uh, tool to give a opportunity of being heard to the other party, and therefore you capture a reasonable time or something which is captured in your commercial contract as a time frame for the other party to comply with your directions. And obviously, the last two portions are very important portions, which is signing of legal notice and the service. If it is a lawyer, obviously the lawyer will sign it off and you don't have to bother about it. However, if it is a notice which is sent in-house, then it's always advisable to first see that the person who is signing off that legal notice for and on behalf of the company is an authorized signatory for the company. Uh, this fact may not seem that important, but when the matter reaches the court and reaches the stage of leading the evidences, sometimes it may actually just one single statement made at the time of cross examination that the person who has signed did not even have the authority, and therefore this notice has no basis, can spoil. I'm not saying it will spoil the case for you, but it will kind of spoil the basis from where it started for you. So it's always important to see that the person who is signing off for and on behalf of the company has a due authority in his name or her name to execute the legal notice, and obviously the service. We discussed it in last session also, where we said that the services by multiple modes are acceptable by the courts and under Indian law today. However, if your contract specifies certain specific modes of service and certain specific ways in which the delivery of service will be assumed to be accurate delivery, then it's better to follow that and therefore pull out the contract, see the notices clause, see the notices to whom it has to be marked, and then follow the procedure prescribed therein. Otherwise, it may so happen, Arnab gave the example last time of a British company, etc. And it may so happen that all this effort may go to waste if you're not serving it properly to the party.
That's right. So, so all the essentials which we have discussed, this is how it is placed in a legal notice. You can see those green and red markups. So as a lawyer, this is a basic template, and then the information which we gather from our clients, we frame those information into this format of a legal notice to make it a proper legal notice with a flow, with a cause, with a fact, with the issues, with whatever is our grievance, and what is the remedial measures which we are looking at. Now, coming to different types of legal notice, okay, so there can be multiple, as many kind of a contract, as many kind of a legal notices can be there. Okay. But some of the important are like which you see in your day-to-day issues is any kind of legal notice under contractual agreement with your vendor, customer, any agreements has a legal notice and dispute resolution mechanism. The second is with regard to the non-payment of dues, which becomes a very specific kind of legal notice. And of course, your employment and employment disputes and all those things, people getting terminated, disciplinary actions, all those things are also falls under legal notice. And the fourth one is the arbitration notice. Now, arbitration notice is not a separate kind of a notice. It's basically all these agreements, if they have an arbitration clause, then for sending a legal notice for a dispute, one is also required to follow the arbitration clause of that agreement, which requires them to either ask the other party or mutually decide arbitrator and all those things. So those kind of a notices where arbitration clause are there, one has to see that whether first to send a legal notice. Once that is not responded, then we should go for a placement or creation of an arbitral tribunal, or we should collaborate, club both into one. That this is my dispute. Let this dispute get sorted. If you're not ready with it, let's get the arbitration done on it. Okay. So at times we have seen that in most of the agreement, it's a common I will not call it a myth, but it's a common point that arbitration is faster and cheaper. Now it depends on what contract size we are talking about. Okay, if it's not a universal truth that arbitration is a faster and a cheaper mode of resolving a dispute. Okay, if it may be for a bigger matters, it may not be for employment or smaller matters. It depends. Now, certain kind of these arbitration notices has its own nuances and challenges. About your take on arbitration clause, if anyone has an arbitration clause in their agreement, while sending a legal notice, what other things they should keep in mind?
So, as you rightly said, I mean, arbitration is something which typically a commercial contract captures in maximum detail. If the parties actually intend to take their disputes to an arbitration, then it's an act which gives parties the freedom to choose where they want to have the venue, where they want to have the seat, what sort of arbitration panel do they want to follow, what sort of procedures do they want to follow, etc. Everything is party driven. So parties have the right to choose all these things and then capture them in the agreement. Once that is captured in the agreement and both the parties have agreed to it, uh, then that's going to be a dispute resolution mode for the no civil court then can take a suit which is filed in an agreement where the arbitration was the preferred mode for the parties. Now, if you have captured everything in the legal notice as to the procedure, etc., then the easiest thing is to follow the procedure and go by the procedure prescribed in the notice. If sometimes it so happens that the agreement captures that the parties will mutually decide upon a name. It's a it's a single arbitrator panel that we want to choose, and therefore the agreement says that parties can mutually decide on a name. It's always better to, again, it depends on the facts of the case where you want to quickly move with the proceeding, it's better to propose the name itself from your side, depending on what sort of criteria for the arbitrator you have given in the agreement. Propose the name from your side and ask the other party or call upon the other party to agree or suggest a name from their side. If that doesn't work, then you have your option of approaching the high court in the high court or a commercial court in the relevant jurisdiction open for you to under section 11 to go and get the arbitrator appointed. So uh, whenever you send the arbitration notice, keep an eye open for what's captured in the agreement. If nothing is captured in the agreement, it's best to go to the lawyer and decide the strategy forward, because all your applications under section 9, section 11, etc. will then depend, the strategy will then depend as to how quickly or at what point in time you move with what details in your notice. So if your arbitration clause is very vague, then it's better to go to a lawyer and then get a notice drafted from there.
Yes, and as a usual practice, which I think of always for our clients, is that if they're entering into an agreement with a foreigner or foreign company or anything, then I always prefer for a arbitration clause, because then I know that arbitration will follow certain kind of a procedure, may not be very much related to that rule of domestic jurisdiction of that other side. You know, like for example, if I'm entering into an agreement with a U.S. party and U.S. party is insisting me to make this, governing law subject to a U.S. law or a U.S. jurisdiction, then the next should be best option for me to go for an arbitration on a neutral jurisdiction, and if provided, if it can be done through a arbitrational institution arbitration. Okay,
Yeah,
because then you are out of that local issues which you are not aware of.
yeah,
At least to a fair amount of things, we understand how international arbitration works. And then,
yes,
in case you lose that matter or something goes wrong in that matter, in order to execute that arbitration order, one has to come to India and again test the Indian laws against that arbitration order. So you are double protected that way. So whenever our clients are signing up with a foreign party, if the choice is not India, then always better to choose for arbitration. If you're signing up in India, then do the cost time benefit analysis, because it's a common thinking that it's faster and cheaper, but that may not be true for every case. Now, coming to the other thing, and this we discussed last time also from the other side, that if a counterparty refused to sign or accept the legal notice or change in address, we have discussed this last time. So technically, if that happens, if they don't sign it, or they don't accept it, there is a presumption that it was delivered to you and you have the understanding of that particular notice. Okay, what the other side has to prove that it was sent to their office or it was emailed to them. Okay, now if they're claiming that it has not been received, email is the best mode where someone cannot deny not receiving it. Even if it goes in spam, that's not a reason, until unless you get a bounce back that that email doesn't exist anymore. It is always deemed that it has been delivered to the other side. When it comes to registered post and all those things, it depends what the what rebound you get. Whether you get someone has respond, nobody was found in the office, office was locked. Even if the office was locked, the registered post will try 3-4 times going to the office at different point of time. So it doesn't happen that they go. So technically shows some kind of effort of you delivering that notice to the other side. If then also the other side doesn't sign, then the assumption is that they have been avoiding to take that notice, and one can claim or show that it's malified on their intention. But it's very very vague that way. So always in your agreement, try to capture the email address, and try to capture email address of of a little permanent positions, like CEO or a MD or a someone who is going to be there in the organization, not at a junior staff level, because they keep on changing the job. So you may end up with a email address which is blocked by the organization after a while. So if an agreement is of worth, then someone higher in the management should be signing that agreement. So I won't take that much time there. So now coming to the foreign company, foreign resident, this also we discussed just now, that arbitration is something we will look for, and Most of the time, our client comes to us with regard to governing law clause that other party is not agreeing for a India related governing law and all those. Now we have started suggesting Gift City as one of the other avenue because even though it's a part of India, but the international laws and all those things can still be worked out there in the way the other side wants. But in a worst to worst situation, if someone is just not willing to take any other or nothing in India, then in that case, arbitration, neutral jurisdiction, anything in Dubai or Singapore is something which can be advisable of it. There are some of the common mistakes which one should avoid. Amol, you, if you
Yeah,
can highlight some of these things, yeah.
yeah. I mean, so we've discussed the essentials that a legal notice should carry. If you miss out on any of those, anyways, it's going to be a problem because, uh, say for example, if you have not captured the facts or the breaches or details of the breaches that have happened in the agreement properly, it's a problem because you are not letting the other party. Just keep in your mind that it's a reasonable opportunity of a being heard. It becomes reasonable not only because of the time, but also because of narration of all the facts and circumstances leading to a dispute. And therefore, it's important for you to capture all the details leading to a dispute very clearly. Keep in mind that, again, as we spoke, limitation is important. There's time of limitation act which gives you lots of limitation, and therefore that's not a problem. But there are certain statutes which give you a specific timeline for sending out demand notices or uh, notices to the other party. You'll have to follow that. If you breach that tax statutory timeline, it's very difficult for you to then justify and take your case forward from there. If your contract has specific timeframes prescribed, follow those timelines. Uh, Typically, lawyers' notices, corporates assume that the lawyers' notices have a little aggressive tone. But here by aggressive, we mean that uh, better to keep a professional tone, better to be very clear in terms of narrating the breach, etc. But there's no need to be aggressive. While at the end of your notice, you will obviously say that if the demands are not met within such and such time, you will forced to approach the court, etc., etc. But yeah, you don't need to use the court. Then I'll see you in court kind of language. So be professional in your language. Uh, be very clear with what you are asking or what is your ask from the other party in terms of demand. Is it remedy the breach, or is it termination and then demand for compensation, or is it remedy or then post that remedy it's termination, etc., etc.? You have to be very clear in terms of the demand. Why you have to be very clear in terms of your demand? Because that also defines the future scope of your dispute. And I'll give you an example. If your demand in the legal notice is just about certain damages or money because you suffered loss, that will ultimately convert into a money suit. But if your demand in the legal notice is about the party remedying the breach and moving forward with the performance of the contract, you may find your remedy in a suit which is filed for specific relief. So you have to be very clear as to what you want the other party to be doing post receipt of the legal notice. Uh, Again, the deadlines, etc. Keep a track of what time you gave to the other party, whether they have complied within that timeline or no, whether they have done their part or no, whether it was a reasonable deadline given or no, etc. Keep track of all those things. And finally, attach all the relevant information and documents. This is a slightly sort of, there will be different opinions about it, but in my opinion, it's always better to give all the details in one go. Again, for the simple reason that it's a reasonable opportunity that you are trying to give to other party. Sometimes lawyer may advise you to not give all the information at your hand in first go, but at some point in time in the course of a dispute, you anyways will have to give that information, and therefore it's advisable to provide all the information and documents or supporting documents along with the notice. There are certain type of notices where you actually have to have all that information being given to the other party. Say, for example, if it's if it's an employment related notice or it's a disciplinary proceeding that you are initiating against one of your employees, and there's an inquiry conducted, show cause given, the charge sheet framed against the employee, and then final termination, etc., that kind of a legal notice, then you have to have the material being supplied to the employee, which he can rely on, then respond to your legal notice. So it's always better to provide the other party with all the information in the dispute.
One of the things which I keep coming across when a client is very aggravated on the behavior of the other side, and when we are sending the legal notice, they tend to send notice to the whole world. When we are sending a legal notice for client, they want to send it to their investors, their other suppliers, bankers, and whoever they feel like. Now, as that practice, I means if that happens, I can sympathize with my client on that, but that's not the way to go about it. And
Yeah.
any what your advice would be on such kind of demand from clients?
So it depends. What is it that you're looking as an outcome from your legal notice, right? Sometimes the legal, or rather, most of the times, the purpose of legal notice is that you want to take it to, if it's not resolved at this stage, you want to take it to the adjudication process and to a court of law. If that's the case, then it's always important to mark it to the relevant parties or the parties who can actually do anything about your legal notice, and not to those who have nothing to do with this legal notice. Having said that, sometimes these legal notices are used as a tool to kind of arm twist the other party to get things done quickly. In which case, if you send it across to their investors, bankers, etc., etc., it's a fear factor that works on two fronts, right? I mean, it creates a reputational harm related fear in their mind, especially when it is going to their bankers and investors. And then probably you arm twist them and extract things. But that can very well go wrong, because then if you are not correct in your legal notice, it may lead to defamatory actions against you also. So it's always
And
better
even
to
the
mark it to people. Yeah.
confidentiality clause, right, means of that
Yeah.
particular agreement.
So it's always important to market to relevant people who actually can take steps to remedy the situation, and not to the entire world.
Now, some of the key takeaways as we discussed, so I will not take a lot of time here. You have facts and whatever we want to put in our notice, we have to work a lot on that, and we should ensure that that is correct. Arbitration notices are another ball game, and we should know when to use the arbitration clause into our agreement. Limitation period and your notice clause of your agreement are very factor through which you are forced to decide the timeline under which you should send a legal notice. And future action plan should be clear. Like sending a legal notice may not end the issue. It may just start the issue. The other party may send you a reply to that legal notice. It shouldn't be like your only action was to send a legal notice. But you should be ready that if a reply comes, then what should be our next course of action? We actually want to go and explore proceedings in court, and so many other things. So it's always better that while we are sending the legal notice, we think through a step ahead and what should be our next course of action while sending a legal notice. So these are the on this topic with regard to sending of the legal notice. Most of you know about LawKNIT. LawKNIT is a full service law firm based out of Bangalore, Mumbai, and Indore. We also have a tech platform which is called LawKNIT Virtual, which we give to our client to manage their entire in-house legal issues. And you are also aware of Nitty, which has come, which is a chatbot, AI-based chatbot for our clients, which generally tend to answer on general legal issues and legal related aspects. Now, next, so as you know, LawKNIT Learning is a quarterly session. We do it for our clients and that too for the non-lawyer, mostly for the non-lawyer team of our clients. Next session will be something around in next quarter, and we are thinking right now to take website terms and conditions, whether that is only for the businesses which is online or it is also for a businesses which is not on online kind of a business. And most of the companies are going through this AI adoption into their customer journey. Either the AI is resolving issues of customer, or AI is bringing more products to the customer. So this entire AI interface, how it works into your terms and condition, and what is going to happen. And in case any of you is also listing your product on some other platforms, then what you should look at the terms and condition on those other platforms. So, this you can expect in next quarter as one of the two session series. That's it from our side. Our contact details are mentioned here. I think we are well within the time. If we can wait for 30 seconds or so, if anyone has any question, or you can always write to us. And we will be sharing the recordings to all that.